So picture this. What if your old boss could legally stop you from taking a new job? It sounds like a modern-day nightmare, right? But the answer actually lies in a legal drama from over 100 years ago, and we're calling it the case of the banned doctor.
I mean, it's a question that's probably crossed your mind, especially if you've ever stared at a dense employment contract. Can your former company really keep you from working for a competitor? Or even starting your own thing just down the street? Well, the answer is kind of complicated, and it all goes back to a story from way back when.
To really get how these rules work, we need to hop in a time machine. The year is 1913. The world is on the edge of some massive changes, and in a small town in England, a little dispute is starting to brew between a mentor and his apprentice.
So on one side, we've got Dr. Foster. He's a surgeon, and he's come up with this special secret process for his work. And on the other side is his assistant, a Mr. Shuggett, who is, super eager to learn the ropes from the master.
Dr. Foster was totally willing to teach Mr. Shuggett his valuable, confidential methods. But this wasn't just some friendly handshake deal. Nope. In exchange for all this secret knowledge, Mr. Shuggett had to sign a contract. And one tiny little part of that contract is about to become the center of this entire story. So what was this super important part of the contract? Well, lawyers call it a restrictive clause, but today we'd probably just call it a non-compete clause.
Now, here's the actual wording from that 1913 contract. I know it's a little formal and old-timey, but it's actually crystal clear. Mr. Shuggett was agreeing to some pretty serious limits on his future career.
Let's break that old-fashioned language down, shall we? Basically, the contract told Mr. Shuggett he couldn't do 3 things. First, the activity. He couldn't practice as a surgeon. Second, the area, not anywhere within 10 miles of Dr. Foster's office. And third, the time, for a full 5 years after he left.
And here is where the sparks really start to fly. After learning everything from Dr. Foster, Mr. Shuggett decides, you know what? I'm going to go out on my own. He leaves and opens his very own surgical practice. The big problem? He sets up shop inside that forbidden 10-mile radius, which is a direct challenge to the contract he signed.
This move forces the whole issue into the courts. And suddenly, it's not just about these 2 individuals anymore. It becomes this really fundamental question about fairness and, how far a contract can really go.
So the court had to balance 2 totally legitimate but totally competing interests. You've got Dr. Foster, who has every right to protect his business and the secret sauce he developed. But then you have Mr. Shuggett, who also has a right to use his skills and knowledge to make a living.
And this gets us to the real heart of the matter. Is it actually fair for a piece of paper to stop someone from doing their job, especially when that's how they support themselves? This is the massive question that judges had to wrestle with.
Now, at the time, the general legal thinking was that any restraint of trade was basically a no-go. The default legal position was that clauses like this were invalid because, well, they kill competition and stop people from working. So on the surface, it really looked like Mr. Shuggett had a rock-solid case.
Okay, so with the law seemingly on Mr. Shuggett's side, what did the court do? Who ended up winning this fight between the mentor and his apprentice?
And here's the twist. The court sided with Dr. Foster. The judges ruled that the non-compete clause was totally valid and they were going to enforce it. Mr. Shuggett was legally banned from practicing inside that 10-mile zone for 5 years.
This is the most important part of this whole story. I mean, if the law generally hates these kinds of clauses, why was this one okay? What was so special about this particular agreement that it basically changed the rules?
The court came up with a new framework for judging these clauses, a way of thinking that we literally still use today. They called it the test of reasonableness.
And the test has 2 simple but really powerful parts. First, is the restriction reasonable for the 2 people who actually signed the contract? And second, is it reasonable for the public as a whole? For a clause to be valid, it has to pass both parts of this test.
So how did this test play out here? Well, for part 1, the court said, yep, this is reasonable between the parties. Why? Because Dr. Foster wasn't just trying to squash a competitor for no reason. He was protecting a real, legitimate business interest, his secret method. The court decided that the 10-mile, 5-year limit was a fair and targeted way to protect that secret. Now for the second part. Was it reasonable for the public? And again, the court said yes. The public wasn't losing a surgeon. Mr. Shuggett could go practice anywhere outside that 10-mile circle, and Dr. Foster and other doctors were still available inside it. Plus, the court argued that it's in the public's best interest to make sure that fair business contracts are actually honored.
And that, right there, is why a case from 1913 is still so incredibly important. It's not just some dusty old story. Its logic built the foundation for employment contracts that are signed every single day, right now.
The decision in Foster versus Sudgett wasn't just about one doctor. It set what's called a precedent. It's like a legal benchmark that has guided courts for over a century whenever they have to decide if a non-compete clause is fair.
So what does all this mean for you? Well, it means that a non-compete clause in your contract isn't just automatically illegal. A court might actually enforce it if it's reasonable. It has to protect a real business interest, like trade secrets or client lists, not just block all competition. And maybe most importantly, the limits on time and location have to be fair.
And that leaves us with a huge, fascinating question for today. Back in 1913, a court thought a 10-mile radius was reasonable. But in a world of remote work and global business, where you can work with someone on the other side of the planet, what does a reasonable area even look like anymore? The principle from that old case is still with us, but figuring out how to apply it to our modern world, well, that's a challenge we are still sorting out.